So welcome to the last panel of your day. Thanks for sticking around and being here. This panel is about criminal records and reentry, although as I'll note later, I think that we're challenged to think in a more expansive way about what reentry means when we talk about records. My name is JASMINE HEISS. I'm the Deputy Director of the Coalition for Public Safety, which is the nation's largest bipartisan effort to reform the U.S. criminal justice system. And what that means is that one of the key tenets of this conference I have the privilege of witnessing in my work every day, which is that in this moment of hyper-partisan division, a shared commitment from the right and left to addressing both over-incarceration and over-criminalization is still alive and well. I feel particularly lucky to moderate this panel because the issue of criminal records is one that is both political and personal to me. And as I was thinking about this conference and about this panel in particular, I was also thinking about the words of Bryan Stevenson and his challenge for us to get proximate to issues, and particularly the way he talks about proximity as showing him a humbling truth that no person should be defined by the worst thing that they've ever done. At this particular moment in America, when 1 in 3 people has a criminal record, I think it's almost impossible not to be proximate to this issue in some way. And so I think that's a challenge to all of us to look at our own lives, to look at the ways in which we intersect with this issue, and also to remind ourselves that the staggering number of Americans who have a criminal record and face barriers to employment, to housing, to social mobility and economic mobility are not simply throwaway people, and that we have to imagine new solutions. Fortunately, I am joined by a wonderful group of colleagues who I deeply respect and admire to talk about this issue. To my immediate right, Bill COBB is the Deputy Director of the Smart Justice Campaign at the ACLU. Next to Bill is Rebecca, who is not on email, I promise, who is the Managing Director for the Poverty to Prosperity Program at the Center for American Progress. And then finally, we have SHARON DIETRICH, who I finally met in person today after admiring from afar for very long, the Litigation Director and Managing Attorney at Community Legal Services of Philadelphia. So I know we're in New York, but I'm just going to say everyone on this panel has a tie to Philly. Do we have any Philadelphia football fans in the room? All right, well, by the end of this panel, I hope you will all be Philadelphia football fans. So we're going to start with a brief video that I'm hoping my friend in the back by the computer can help turn on. Wonderful. Both talking about the issue of criminal records and then one solution.
Most people say, let's give them a second chance, but often we don't get a first chance.
Having a record it affects everything about you.
But you have to understand that everybody makes mistakes. That's why they put erasers on pencil.
There are barriers in which you have to cross. Finding a job, having a stable place to live. And if one is on probation or parole, there are stipulations, provisions in which they have to meet. You know, stable residency, employment, paying court costs and fines, because if you don't, there are sanctions that are imposed on you.
It was just the worst. You sit down with people knowing you're qualified for the job, and as soon as that paperwork comes back or they ask you, have you ever been convicted, it's like you're talking with two heads.
But, you know, after you're given a second chance, after you rectify your mistake, you should be able to go on.
It's the hardest thing, because all you want to do is survive.
We must end the collateral consequences of a criminal conviction.
Let's invest in prevention and not punishment.
Provide hope.
Ensure justice.
Pass clean slate legislation.
Perfect. Thank you, friends, for coming back. So Rebecca, can you tee us up coming out of that video? It talked about clean slate legislation, and you have been a force to be reckoned with behind that reform effort. True, yes, don't be too modest. So can you sort of lay out for us what clean slate is, the problem that it seeks to solve, and then where it is positioned within this larger range of efforts to address records?
Jasmine, thank you so much, and thank you to everybody for being here. I feel like this is a small but mighty crowd. I can tell looking at you guys. We've got the right people in the room. So let's make this an interactive conversation. So I am really honored to be here today because the issues that we're talking about are perhaps closer to my heart than anything else that I work on. Jasmine mentioned I manage the poverty team at the Center for American Progress, a big progressive think tank in Washington. It's actually quite nice to have a break from Washington today, so it's nice to be here in New York. But of all the issues that I work on, the one that sticks with me perhaps the most from my days as a legal aid lawyer working for this one over here, who if you think I'm a force to be reckoned with, you haven't met Sharon. My clients, by and large, were people with criminal records, and often incredibly minor criminal records, that even misdemeanors, even arrests that had never led to a conviction, these were the types of records that could literally be a life sentence to poverty. And I saw that firsthand day in and day out. Sharon still sees this day in and day out, and she'll talk about that as a legal aid lawyer representing these individuals and their families. Transitioning into doing policy work, which I now do at the Center for American Progress, I've now started to sort of move into the research space, the policy advocacy space, in a way that now helps me put numbers to what I saw every day as individual clients, whose faces, whose names, whose lives I knew. And I want to start a little bit, before I get into what Clean Slate is, with the problem that needs to be solved. And it all wraps up around that number that Jasmine just mentioned of 1 in 3 American adults now having some type of criminal record, which has really passed the point now of being a them, and now it's an us. So a few numbers to help paint the picture of why we came up with the idea, Sharon and I, for the Clean Slate legislation that you just heard about, and then we can talk a little bit about that. One number that helps perhaps to illustrate the linkage between our broken criminal justice system and poverty better than anything else. It comes from a study done by researchers at Villanova in Pennsylvania. And that study found just a few years ago that our nation's poverty rate would have dropped by 20% between 1980 and 2004, if not for the recent trends in mass incarceration and the subsequent criminal records that people end up having like a scarlet A on their chest for the rest of their lives, long after they've paid their so-called debt to society. And that number becomes common sense when you start to think about all of the doors closed in your face if you have any kind of criminal record, whether it's employment, whether it's housing, whether it's even basic meager public assistance, education. All of these things can be absolutely closed to you no matter how hard you try, no matter how much you have become redeemed, to use the language often used in this context. And I'll give you a couple of additional numbers to help paint that picture of how this plays out. So 9 in 10 employers conduct criminal background checks on their applicants. This is something Sharon sees with her clients to this day, and also sues the pants off a lot of those lawyers when they do it illegally. But I should note that this doesn't end up just being an issue of a temporary bar that someone can face, because as a result of those criminal background checks, some 60% of formerly incarcerated individuals remain unemployed a year after they've been released. And for people who do find steady employment, a history of incarceration is associated with a staggering reduction in earnings. Formerly incarcerated men work 9 fewer weeks per year and take home 40% less pay annually. And that results in an average earnings loss of nearly $180,000 by age 48. So we're talking about a massive link here between our broken criminal justice system and not just poverty, but also inequality, and specifically racial inequality. Really an inextricable link here. Now, notably, the lifelong consequences of having a criminal record and the stigma that can accompany one stand in stark contrast to the research on redemption. So for example, and this is really, really important new research that's come out over the course of the past couple of years, helping bust through sort of that stigma and the myth to really see the reality. Once a person with a prior nonviolent conviction has stayed crime-free for 3 to 4 years, that person's risk of recidivism is no different than the risk of arrest for the general population. Yet, we treat them as though they are some criminal with a capital C for literally the rest of their lives, long after they pose any significant risk of committing further crimes. And as Jasmine noted, we're talking about 1 in 3 American adults. But wait, there's more, and that's because this has broad implications for families and for entire communities. So in fact, analysis that the Center for American Progress published just about a year ago found that between 33 million and 36 million children, that's nearly half of American children, now have at least one parent with a criminal record. That number is truly staggering, if unsurprising, when you consider how many adults have records. But this is the legacy of our nation's failed experiment with mass incarceration and overcriminalization. It's that we've not only created effectively a permanent underclass of people with records, but we are compromising the entire next generation's chances of actually being able to succeed. The barriers associated with a parent's record not only affect family stability and economic security in the short term, our research finds, but they also severely limit a child's life chances. They inhibit cognitive development, educational attainment, even adult employment outcomes. This is what's happening because of every door closed in people's faces because of a record. So I want to now take it back to what is Clean Slate? Why did we move in this direction? So the momentum has been absolutely amazing over the course of the past several years, especially at the state level when it comes to policies to give people a second chance, to remove barriers to opportunity for people with records and for their families. Earlier, Governor Deal was talking about ban the box. Some people call it fair chance hiring, something that has truly swept the nation, both cities and states, and we've seen a tremendous difference that it can make. We've also seen a tremendous expansion across the states when it comes to the types of records that people can have expunged or sealed. But what I saw as a legal aid lawyer, and what Sharon still sees every day to this day, is that there are countless people out there who cannot actually access the remedies that exist on the books. And I'm thinking particularly here about expungement and sealing. And that's because you effectively need to be able to have a lawyer to represent you if you're going to have any reasonable chance of being able to get your record expunged. You're going to have to file a special petition. You're going to have to go before a judge. You really effectively need a lawyer. And guess what? Take it from a recovering legal aid lawyer and one that you're about to hear from. And that's, there just aren't enough of us to go around. And that is sheerly for lack of resources. These are not cases public defenders are typically able to handle. And they're not, this is not a population of folks who is rolling in money for all the reasons I just described, so they're not able to afford private lawyers either. And so what do we have? We have theoretical remedies that people are not actually able to access. And so the idea behind Clean Slate was, you know what, it's great that we're banning the box on job applications. That's going to be really important in the employment context. But what about everything else? What about housing? What about education? And what about all the folks who are still going to be discriminated against, even if that box is banned, subject for a whole other conversation. And so we said, you know what, it is time for people to be able to discharge their records just like you do in bankruptcy, and to have that done automatically when you have remained crime-free for a certain period of time, showing that you've been rehabilitated, whatever kind of language you like to use. That's the idea behind Clean Slate. I know we're going to talk a lot more about the success that it's seen in Pennsylvania. We had a bunch of friends from the NFL who have become huge fans of Clean Slate and who are out there lobbying in Harrisburg as we speak, trying to move forward this first of its kind legislation, which truly does present a model for the rest of the country. So really excited at CAP to be partnering with Community Legal Services on the Clean Slate campaign there and expanding it to states across the country as well in the coming months, and really excited about the discussion today. I'm sure we'll get much more into the nuts and bolts of how Clean Slate works and how that campaign is going. But does that give us a good jumping off point, Jasmine?
It's beautiful. Thank you so much. And next, I'm going to turn to Sharon, who you referenced many times, and I've been told was called learned today, which I already agree with. And I'm going to ask you, Sharon, to help us get a little bit more proximate, just in the way that you encounter this challenge in your work every day. I'm going to pull up the next slide. And this shows, not only the sort of scope of the challenge that you encounter as a legal aid lawyer, but also a pretty astronomical growth over time. Can you talk a little bit about the implications of this and then really how these issues crystallize into reality for people?
Absolutely. Hello, everyone. Thank you for having me here today. So I just had my 30th anniversary at Community Legal Services, which I find kind of stunning.
Congratulations.
But thank you. But that really is about the fact that my job allows me to do some significant work in a significant context, I think. I'm lucky that I am able to represent I've represented many thousands of people over those 30 years, and what we like to do in my program is to turn our clients' experiences into impact change, systems change. But it always starts with the client somewhere. And I still remember to this day a point at which I met a guy in the late 1980s who came to me and said, "I've been fired based on my criminal record, can you help me?" And you know how in the AIDS crisis they talk about patient X? To me, this was client X, because it was the first time I'd ever heard this. And now here I'm an employment lawyer in legal aid, and I immediately had this light bulb go off in my head, and by which I said, God, I bet this happens all the time. How comes I haven't heard about this before? And what legal remedies might exist for this person? It would seem like it would have a racially disparate impact for employers to be rejecting people under Title VII. So I remember that much about what I learned in law school about Title VII. I wonder if you can clear records. I have no idea. And from that first client in the 1980s, and I know it was the 1980s because I actually recently found the charge of discrimination I filed for him in 1989. Now, having a criminal record is the single most common reason people come to community legal services for employment-related help. So on this chart behind us, the tallest bar is our overall employment intake. Anything that a low-wage or unemployed person in a city of 1.5 million people, which has the highest poverty rates of our top 10 population cities, of any reason they might come in, wages not being paid, family medical leave, traditional discrimination, disability discrimination, all of those many things that they might come in for. Having a criminal record by far is the number one reason they come in, which I still find astonishing, and it's why I carry this chart everywhere I go. And so the red bar, the high bar, that is our overall intake. The blue bar is the criminal record cases, and as you can see, the blue bar keeps pushing the red bar up, because there's essentially a infinite demand for the services that we provide to people with records. Now, the folks that I represent are on all different ends of the spectrum in terms of seriousness or lack of seriousness of the offense that they have. On the one end, we certainly have people who've done some significantly bad things that they would agree that they did. We do not tend to have a lot of people who have the sort of background that really might legitimately make an employer say, I'm really nervous about having you in my workforce. Because most of our cases are the other end of the spectrum, sometimes to an almost comical degree. We represent just untold people whose criminal record consists of non-convictions. They were arrested, the case was dropped, maybe they were found not guilty, and still having that little tiny smirch on their record that they were arrested but not convicted has caused them to lose jobs, often repeatedly. We have people with such minor convictions that you cannot believe it. The story I like to tell is a woman who I once represented who was fired from a good job that she needed to provide for her family because she had a summary offense of disorderly conduct making a loud noise, right? Making a loud noise, criminal conduct. I mean, if you want an example of how we've over-criminalized things in our country, what could be more of an example than that? And yet, even such a minor thing that is below a misdemeanor caused her to be fired. I'm happy to report we got a good settlement for her. Yeah, we have untold numbers of clients whose convictions are 10 years old and older, sometimes 20, sometimes 30. And the principle you can take from this is that there is nothing too minor or too old that it no longer constitutes any kind of problem for people. It just goes and goes and goes. And so this fraternity and sorority of people with a criminal record legitimately, in my mind, constitutes everybody who's ever had any connection to the criminal justice system, because they can all equally face the same consequences, no matter how minor or not the crime was. Now, a lot of this has to say something, and I'm still trying to struggle to find out what it is, about some mindset that developed in the 1990s when background screening became prevalent. Because really, that was when these bars started to go up. Before then, if you had a record, chances are nobody really knew about it because there was no organized way necessarily for employers to do background screening. I had a client who once told me that it was easier for him to get a job when he came out of jail in the 1970s than it is now, because there was no background screening then, or at least very little, and now every employer, as Rebecca said, is doing it. So sometime when that started to happen, employers and landlords and now colleges more and more are starting to say there's something talismanic almost about having a record. And if you have a record, then you're not safe, you're not trustworthy, you're an other. We don't want you here. And there's so much for society to learn about what it means to have a record. And that's part of what we've tried to educate people about over the years. And I'll stop by just giving you a basic sense of the kind of work that we've done in our legal aid program as a result of all these clients coming in seeking our assistance. We have done a lot of work under Title VII, the federal race discrimination law, to argue that when employers turn people down for cases that are not really proof of any kind of risk, that is a form of race discrimination because of the racially disparate impact on African Americans and Hispanics. We have a state law, now we have a city fair hiring law. We try to enforce those as well. Also limiting employer discretion. Pennsylvania had a law that was totally over the top that our state legislature passed that governed who could work in the long-term health care industry. And it basically said if you were ever convicted in your life of anything from murder to library book theft, yes, library book theft, you were prohibited from working in home health care and in nursing homes, et cetera, et cetera. We had that law struck down as unconstitutional. That didn't take, just that the court found it unconstitutional, so later we had to sue again and have the court actually enjoin its being applied, so we did that. We've sued many background screeners for turning out the worst crap of product that you can ever imagine for all kinds of things, as different as confusing lots of different people's records under one person's name. In other words, your name is Bill Cobb, and they might actually report the records of many other Bill Cobbs rather than or in addition to your own. We've sued for calling misdemeanors felonies and summary offenses misdemeanors, for reporting arrests that are more than 7 years old, on and on and on. There is endless work that we can do in this area. But the thing that we have determined from these many thousands of clients that we've served over the years that is most meaningful where it applies, and it doesn't apply to everyone, is to clear their records. And when people come to legal aid, they don't usually say, I'm here to sue that bastard employer that just fired me. In many cases, they've moved on from that bastard employer, and they're down to, I'm ready to look for the next opportunity. I want to leave that behind me. Please help me clear my record. And so doing expungement, doing sealing has become really, in many ways, our most important thing we can do for people. And if you want to know how important it is for people, it is the one area that I practiced in that people often cry. Tears of joy when you finish their case. And sometimes you've done like nothing except file a petition. But they recognize that having gotten this thing off their record, even if it's just a non-conviction, really has markedly changed their life opportunities. So that is why, for the reasons Rebecca has talked about the great things that expungement and sealing can do for folks, that we were so excited about engaging in this clean slate advocacy. Because if we can do that on a mass level, we can make a difference to many hundreds of thousands, and dare I say, potentially even millions of lives.
Thank you so much. So talking about those millions of lives, Bill, I'm going to put another chart up behind you, which I know you've seen because you helped create it. And it lays out really, I think, the scope of this challenge and how complex some of the solutions have to be. So can you talk to us a little bit about, why is Clean Slate just one piece in this larger puzzle? And then what is the challenge to us to think more expansively about shifting culture and not just policy?
Yeah, so my personal experience would exclude me from benefiting from the outcomes that Clean Slate would produce, as my offenses are not in the range in which the version in Pennsylvania is being advocated for. However, we realize that people enter into the criminal justice system and their level of interaction varies based upon what they are initially accused of and whether or not they have to do time. So this version really touches some misdemeanor offenses and I think conceals some other things that are just a little bit higher for that. So that's great for individuals who have had offenses that were not felonies. And then in Pennsylvania, our law doesn't allow you to, like, expungement and sealing and all of those things are differently defined in different spaces. So in Pennsylvania, if it's a criminal conviction, an expungement isn't going to suffice, a sealing isn't going to suffice, it needs to be pardoned. So in conjunction with what Clean Slate does in this Pennsylvania, and I hope that in other places where it's politically viable, that we aim to make it more aggressive, so that way it can actually reach a broader number of offenses. But you need those things in addition to pardons. You need those things, and you need to increase the threshold of offenses that can be sealed or that can be expunged. I think it goes back in terms of like 10 years.
Yes.
So sometimes, as Sharon indicated, that 4 years, after a period of 4 years, that person is not likely to offend. Or they're saying the percentage in which they will offend is just like anyone else who hasn't been in conflict with the criminal justice system. So why wouldn't 4 years be suitable after we have an indication that that person no longer possesses the same level of threat in which they did? So we can lower the thresholds, we can expand the number of offenses which are eligible for that, and then we can add that to the toolbox of other things that are being done to kind of sort of deal with the collateral consequences of a criminal conviction. With 100 million people being impacted by the issue, it isn't a they thing anymore. It isn't us. If you are a person who has been arrested and or convicted, you are in proximity already with someone who has, whether it's a family member, whether it's a community member, but we all know people who actually live with criminal records. I think what Sharon talked about, it not being a thing. Well, it became a thing when individuals realized that they could capitalize from it financially. So our usage of criminal background checks has been given to us by an industry that benefits from it. So you have these companies come up, realize that they could actually add value to their bottom line, or they could create value to potential employers by completely just giving out falsehoods. one of the things that we hear more frequently than not when talking about this work as to why people do criminal background checks is because they want to avoid the liability of hiring somebody with a criminal record who may do harm to another tenant or to a student or to an employer because they don't want to be sued. But we know that people are very, very rarely sued successfully as a result of negligent hiring practices. This industry has put these out, they've become truths in people's lives, and people think it's necessary to protect their organization or their institutions, that they need to vet out people who have been in conflict with the criminal justice system to ensure that they are maximizing the environment and making sure that it's safe for everybody that enters it. But it's all true. It's all, none of it's true. It's really a myth. And if we don't get to work on making sure that expungements, sealings of criminal records, if we don't do that, then we'll never get to a point where we are effectively combating this pervasive culture of discrimination aimed at people who are living with arrest and convictions. It's my dream to lead an effort where people with arrest and convictions becomes a protected class of citizens. I want the capacity to be able to sue anybody that wants to perpetually punish me after I've paid a particular debt to society. I've done my time, so I've earned a second chance. I don't need to be given a second chance. We spend our time in prison. We're no longer engaged in criminal activity. We're not in conflict with the criminal justice system anymore. And being punished beyond the initial sentence, I don't know why we call them collateral consequences, right? It's a direct consequence of a criminal conviction. So I think that our terminology kind of sort of softens the impact that, but it really is, everybody knows, from the judge to the prosecutor to the arresting police officer to any of the counselors in the prisons, to everybody knows that a person who has a criminal record is now going to have a very difficult time with pursuing their hopes, their goals, and their dreams upon their release. And it's a system, and we're all playing a part of it.
Well, let's stay there for a minute. I'm not going to let you off the hook. You talk about language and softening language, and I think, as I sort of alluded to at the beginning of the panel, one of the phrases that I think that can be misleading is this idea of reentry. So when you are living with a lifetime sentence from a criminal conviction, reentry is no longer leaving a jail cell or a prison cell. It is a lifetime of fighting to extricate yourself from the justice system. So what does that look like? How would you challenge people to rethink reentry?
So that is an amazing question, and I knew it, but I still don't have a great answer, right?
We're glad you got asked it, Bill.
Yeah, well, since I am a person who
Take it
has
away.
re-entered or is in a constant state of re-entering, it's a profound question, right? Because I've been removed from prison for 17 years now. Actually, SHARON was my attorney at CLS, which kind of sort of put me on a very different trajectory in terms of my advocacy. While I'd always been doing advocacy, I hadn't been doing it at the level in which I did once I was informed that there were protections in place that I wasn't aware of. So I've been home for over 10 years. I've been hired and fired dozens of times, and I just thought that that's the way things go, right? But you're working, you're at a place for 2 or 3 years, and now you're no longer impacted by having a criminal record, unless you're talking about trying to acquire life insurance or something like that. But for the most part, you're fine until that day happens when that employment is terminated and you find yourself in the stage of re-entering again. So you can be employed gainfully for 10 years, have to come up. Actually, Sharon and I were talking about how people are employed at an organization for 25 years, and you're unaware of the fact that they've been in conflict with the criminal justice system until they need to talk to you about possibly getting their record cleared, exhaling or an expungement, so that they can actually reapply for a place of work and not be discriminated against because of it. So in terms of the terminology, I don't know what we can offer the field or the movement that'll actually get people to think about it differently. What I'll say is that we currently know that if you've been in conflict with the criminal justice system, there are barriers to employment, there are barriers to housing, there are barriers to education, there's just barriers to quality of life. We said now that there are 50,000, there are 60,000, or whatever the numbers are, but the truth of the matter is that reentry, I think, happens instantly from the moment that you're left, and you're re-entering the entire time. What you're trying to do is live the same quality of life as someone who has not been in conflict with the criminal justice system. And you're going to be doing that for the balance of your life, unless I'm successful in my dream effort of making sure that we can sue people. Not that that will actually change, right? But we know that if you have the capacity to actually sue somebody, and people are educated as to what their rights are, which is another huge barrier. Sometimes we go into court, we win pieces of legislation, we enact new laws, but the practice doesn't change because people don't know that it has changed, or that the standard or the norm should no longer be the norm as a result of work that was done. I know that that was my experience with CLS, and the moment that I found out about Title VII, about the Statute of Pennsylvania, about the Fair Credit Reporting Act, it changed my life personally, and it changed my professional advocacy trajectory.
Perfect. Thank you for tackling the tough question on behalf of everyone else. And with that, I'm going to go back to Sharon with this question of Title VII and litigation. It's a tool that you have in your toolbox that sort of goes beyond just policy change. So where does it work? Where does it fall short? And how does it sort of call us to think about further solutions?
Okay, here's where I do the lawyer thing. So when you so let me start by explaining what the claim is in case people don't understand it. I kind of went over it quickly earlier. Essentially, under the race discrimination law, the federal law that applies to us all, I once had a client tell me, we don't have any laws that protect us in Texas. I said, damn straight you do. It's called federal law, duh, Title VII. Title VII says that if there is an employer policy that is not intentionally discriminatory based on race, but it tends to exclude African Americans and Hispanics more than whites, and the employer doesn't have a sound business reason for why they're using that policy, then it violates the law. So that means you can have an employer that's doing background screening and maybe, with the kindest of hearts is not looking to be racist, but nevertheless is excluding lots of African American applicants because the policy is written in a broad way, and if you've had criminal justice involvement, you're not going to get the job. African Americans are more likely than whites not to get the job. Now, there are two ways to enforce the law. And actually, you need to do the first in order to be able to do the second. The first is you file a charge of discrimination with the Equal Employment Opportunity Commission. And that's all fine and good, and sometimes even great. We've gotten some good results out of that. But EEOC can only do so much with the charges that are filed with them. It's easy to file a charge. It doesn't require a lawyer. And most importantly, you don't even have to prove that there has been more of an impact on African Americans than whites. That will be presumed to be true for good reason, right? I mean, because we've all read the research. We know this is true. But in the many cases where EEOC is not able to resolve that case, then you have to think about going to court. And if you have to go to court, you actually have to prove the racial impact, which is kind of beside the point, because the important question from my perspective is what Bill said. He wants a law that says that if you're being rejected for a record that does not really say that you're not fit for the job, you shouldn't have to go into a whole thing about proving why race entered into it. It's a very expensive thing. It's a very complicated thing. In fact, EEOC has been sanctioned in cases for not having met their burden of proof, and they're the experts. So it's not the best tool. We would be better off with a tool that applies just to anyone who has a record. And employers should have to look at, do you present a risk or do you not present a risk? Unfortunately, the race discrimination law adds this whole other level of complication. It does mean that people in Texas have rights, even if the legislature in Texas is not going to enact the kind of law Bill wants to see, but it is just an imperfect tool for the job.
Thank you. Super helpful. So to talk then about what makes it more perfect, Rebecca, you foreshadowed a little bit that you would talk about sort of the nuts and bolts of clean slate and in Pennsylvania. I'm also curious to hear your thoughts about what clean slate sort of illuminates that needs to be fixed at the front end of the system or elsewhere in the system.
That's a great question. You're full of all these hard
Thank
questions.
you.
Why did we let you moderate? These are hard questions. So to get back to clean slate, and it sort of stems from all of what we've been discussing today, right, which is why existing laws on the books are great. They're a step in the right direction, but don't necessarily quite get the job done. Well, I'm not going to sit here and tell you that clean slate is the last thing we ever need to do, because it's not. But here's why it gets us farther, and here's why I believe it truly is the next wave of second chance policies, which makes it incredibly notable that it is as full-throatedly bipartisan as it is in Pennsylvania and now in other states where it is a burgeoning campaign. So the nuts and bolts of clean slate is, you're that person, you've got that record, it's a misdemeanor or below in Pennsylvania, and I really appreciate what Bill said earlier, sort of planting the seed that this is not a policy that has to be done the same way everywhere. This is how it's been fashioned in Pennsylvania, but the model that can be taken anywhere and scaled up, scaled down, depending on the state's political climate, really is this. It's automatic sealing of your record if it qualifies, once you've remained crime-free for an agreed-upon amount of time. Now, that could include, say, drug felonies. This is a conversation we're having in a handful of states that want to go farther right now than Pennsylvania has. Shorter wait periods for states that want to be more ambitious. But then there are other states that are going to say, we're not quite sure we can go as far as Pennsylvania. And you know what? All of that is fine, because this can work and be dialed up and dialed down. But that's really what's at the heart of it, is that automatic sealing. Now, there are a lot of reasons why this policy has become beloved by pretty much every stakeholder group, whether you're progressive, whether you're conservative, whether you're an employer, whether you're a worker with a record who's being shut out of the labor market, whether you're law enforcement. All of those stakeholder groups have come together in Pennsylvania and said, you know what, this is something that we want to happen. And I'll walk through a couple of reasons from different vantage points for why that is the way it is. You might be surprised to hear that law enforcement thinks this is a good idea. Well, guess what? A huge part of that is because the way that we've fashioned the policy is that it's record sealing as opposed to expungement. And so law enforcement gets to actually keep access to the record moving forward, and that's something that's really important to them, while it's shielded from third parties. So employers aren't seeing it, housing authorities and landlords aren't seeing it, 4 out of 5, by the way, of whom are doing criminal background checks to pair with that 9 and 10 number. Higher education institutions, job training, all these kinds of places, they're not seeing it. And guess what? 3 and 5 institutions of higher education are doing background checks. So these numbers really span all those different areas. But so that law enforcement says, you know what? We like the sound of this. This is something we can get behind. And guess what? It actually reduces their workload, because rather than having this huge influx of petitions coming in of one-off, I need to get this arrest expunged and that arrest expunged and that misdemeanor expunged and go before the courts, and all the DAs have to send their lawyers to go stand before the judge and say yes or no, right? They actually love the idea of minimizing that workload. So there's one stakeholder group for you that loves it. But then there's the employer perspective, and you've actually got a whole bunch of employers out there saying, I've got a shortage of skilled workers. I can't find workers to fill my jobs. And we're over here saying, great, because we've got a bunch of workers who would love to fill those jobs if we could just get past this issue of them having a record that you're going to look at and say, I'm afraid to hire you because of what Bill said. I'm afraid I might get hit with a negligent hiring lawsuit, something that really is overblown but really persists in employers' minds. So guess who the prime sponsor in Pennsylvania of this bill is? He is, I'm going to go ahead and say this with a nod to my dear colleague in the back, Erin Cohan, who runs government affairs, state and local government affairs at CAP, who should get a shout out because she's our partner in crime on this campaign with me and Sharon. I think this is fair to say, Erin, our prime sponsor in Pennsylvania in the Senate is possibly the most conservative member of the Pennsylvania, and Bill says absolutely, so I'm going to take that. He is absolutely, you heard it here, the most conservative member of the Pennsylvania State Senate. Why on God's green earth is he such a fan of this bill? Well, it's because he's an employer. And he starts almost every sentence with, well, as an employer, and finishes it with his perspective on how he needs to cut through that shortage of skilled workers. So there are all kinds of reasons why people have come to the table and said, this is something that because of my progressive values, because of my conservative values, because of my faith-based values, this is something that I can get behind. And it's been absolutely amazing to watch the success that this campaign has had in Pennsylvania, which I think proves it can be successful just about anywhere, given what that legislature looks like.
Absolutely, go for it.
I just want to piggyback on Rebecca's answer, and I want to talk about why I'm excited about this piece of legislation that won't even impact my life or the vast number of people who are convicted of other offenses. I feel like in the criminal justice reform movement, we need to provide opportunities for the 100 million Americans who have been impacted by the criminal justice system to get engaged in the fight and contribute their time, their money, and their resources. And this is a great organizing tool. This is something that has the capacity to impact almost every 100 million of those Americans. And if they can begin fighting for this to restore their quality of life, then it provides us with an opportunity to bring them into the broader movement and for them to begin making contributions. I think none of us in here would say that we have everything that we need in order to win our current fight as it relates to criminal justice reform. What we need is a larger army, a more skilled army, an angrier army, a more committed army. As a professional advocate, we show up, we do our work, we go home, and maybe we feel great about what happened and maybe we don't. But as a person living with a criminal record who's a professional advocate, I don't rest. My fight is tireless. And that's the energy that will come into the space as a direct result of this sort of legislation or this sort of policy change, because it has a profound impact in their personal quality of life. So I'm hoping that we can use this tool to organize and for it to be the clarion call for other people to get engaged into the fight and make more significant contributions on a regular basis.
So if you're interested in being part of Bill's army, come see him after the panel, and everyone should be. I'm going to do a quick myths and misconceptions round, and I'm going to offer one to all three of you, and I want you to obliterate it. So, Sharon, let's start with you. And I heard this earlier today. In this digital age where Google finds everything, even my weird MySpace profile, why would I even get a record sealed? Because it's useless and someone's going to find it.
Yeah, people love that one as a reason to just say expungement and sealing is a total waste. We may get to that place one day, but we are not at that place now. Most employers, in my experience, and I'm an employment lawyer, what I do with like 100% of my time is to try to help people get jobs. They get background checking through either law enforcement records like state police or through the private vendors. HireRight, Sterling, et cetera, the big companies that sell these background checks. And they don't run around checking out all of the Google data that they can pull up. What they do is they get mined data from mostly the courts, sometimes state police, that tell them whether or not you've got a record. It's not to say that it's impossible that these other things might come up, but right now that is not how background screening works in the vast majority of cases. So if you can seal court records and state police records, which is exactly what our bill does in Pennsylvania, the fact that it doesn't seal 100% of things is kind of beside the point. There's still, yes, some very small chance it might come up, but if my clients were told, you have a 90 to 95% chance that your record's not going to come up when you have a background check, how do you feel about that? They'd say, hell yeah. The fact that I can't offer them perfection is not a deterrent.
Perfect, thank you. Up for you, Rebecca. You sort of foreshadowed this, but the myth that, this is going to undermine community safety, public safety, and we should all be in great and crippling fear.
Well, I feel like, Jasmine, your organization's name answers a lot of the question, right? You're the Coalition for Public Safety, and there is a reason why that is an aptly named organization, the mission of which is criminal justice reform. There is no better way to improve public safety, if that's your number one priority in coming to this work and these issues, than to allow people to actually access the second chance that they've earned. There is no better way to improve public safety than to allow people to work, to have safe and stable housing, to be able to go to school, to be able to pursue their passions, to be able to actually provide for their family, rather than being in a desperate situation where they're trying to figure out how to scrape by to survive, and in many cases find themselves with no alternative than to go back to behavior that they didn't want to be involved with in the first place, but often was a product of desperation. And you don't take it from me, I shouldn't really even be the one necessarily answering this question, but I can tell you that from the research perspective, and I can tell you that from the perspective of all of the clients that I've had these conversations with, and I'm sure Sharon can as well, when what you want to do is take that job, but you're being told no, you're going to have to find a way to eat. And that it doesn't make sense as a society to be saying, no, we're actually going to punish you for trying to do everything right from here on out, and not let you make ends meet and support your family. That doesn't make any sense. So in a lot of ways, this policy, because it is such a strong tool for fighting recidivism through that mechanism I just described, it is absolutely one of the most pro-public safety policies that anyone can get behind.
Thank you for that beautiful plug and for perfect myth destroying. Bill, this is the controversial question that I know that you're going to tackle beautifully. You know, this idea that we can only extend these kind of second chances to people who have nonviolent convictions, and that everyone else poses too great a risk, it's too bold.
Yeah, let me provide not a data-driven response, but an anecdotal, all right? And I'll start with myself, right? Robbery, kidnapping, criminal conspiracy, violation of the Uniform Firearms Act. I think among us today are some of the nation's foremost leaders in criminal justice reform who are formerly incarcerated, and I don't know many of us who are incarcerated for having a couple of sticks of marijuana. So the truth of the matter is that the majority of Americans who are arrested, whether they're serving time for violence or nonviolence, are released and have the same needs as any other human being. However, I can answer the question that Rebecca, but I do want to give her credit for doing something, and I don't know if it was a change, but she just said that giving people the second chance that they've earned. And I just mentioned that, so I don't know if that was something you adopted and you're running with, but I would encourage everybody to talk about second chances that way. People aren't given second chances that do time in our nation's jails and prisons. They've earned them because they've served their time. So thank you for that. And I hope that we continue to talk about it that way. However, any person, no matter what offense they serve time for, once they come home, I spent a lot of time in prison, 6.5 years, and I don't recall ever having a conversation with anyone that was rearing to go out and commit a crime and come back to prison. I had lots of conversations about getting a job, about doing the right thing, about never returning back to this hellhole. However, provided that they are not given opportunities, they go out and they end up committing crimes of poverty. And obviously we know once you begin criminal behavior, you graduate because you're trying to acquire more resources. And also if you're in an environment where those things happen more frequently than not, it becomes your normal. So to indicate that the reason that a person went to prison or whatever crimes they pleaded to, right? We know that the majority of people have not been found guilty in a court of law. 97 or 95% are just pleading guilty to whatever charges the DA offers up as a direct result. So defining people by the offense is inaccurate. And then everything after that is obviously inaccurate as well. So it doesn't matter what the offense is, and that's ranging from marijuana to child pornography offense. The truth of the matter is that time served should mean time served if we're actually going to want to make our society a safer and more just society. There's no data-driven answer as to why we need to punish that person in perpetuity and relinquish or stop punishing. We need to stop perpetually punishing people altogether, because it hasn't and will not produce the outcomes in which we desire.
Absolutely. Thank
Jasmine,
you so
I don't know how
much.
we're doing on time, but I want to jump in and just, I
Go
want to
for
say
it.
one thing, because we would be remiss if we had this conversation and we didn't bring up Michelle Jones, who in a lot of ways has opened up this thread of conversation for people who maybe have never had it, maybe have never been party to it, maybe they don't work on these issues, and they're reading in the New York Times, oh my God, this woman who now is like the most competitive applicant in Indiana for a PhD program in history, and she gets accepted to Harvard. The professors were so dedicated to getting her in that they actually filled out the application for her because she didn't have internet behind bars. She gets accepted by the program, and then the university overturns that decision. Now NYU seems to have made a better decision, so way to go, New York, right, just down the street. But that story to me is so important, not because it sparked so much outrage. I was hopeful that that would happen, but because she's not someone who was one of those non-non-nons. Right? She's not somebody who had the non-violent, non-sex related, non-whatever offense. She actually had a much more real story. It was one where when she was a young teenager, she had been exposed to a tremendous amount of violence in her life and trauma, ended up having a child and was not prepared to take care of that child, and the child ended up dying. And it's not entirely clear what happened. But guess what? She didn't have some clear-cut, simple, non story, and yet we are having a national conversation that has as much outrage as it has fueling it, because people are saying, you know what? If she isn't a story about redemption, if she hasn't earned that second chance, who has? To have put herself through school behind bars, to have created a whole program for herself so that she could become the single most competitive applicant for a PhD in history in the state of Indiana, award-winning before she even began that official reentry. People are saying, if that's not redemption, what is? And to me, it's so incredibly important that we have this conversation in a way that doesn't have clean lines around the safe parts, because otherwise we're going to find ourselves painted into a corner that we didn't even notice we were painting.
Thank you so much for bringing that up. And just a plug, Rebecca has a podcast where people talked about Michelle Jones. If you look for the Off Kilter podcast, if you want to delve into it more. You know, what I was going to say before you jumped in was actually pretty much directly in conversation with that, which is that I noticed in the video, I think it's Anquan Bolden says sometimes we're giving people a first chance. Right, exactly. And when you look at histories of violence and trauma and background that so many people who end up in the system have, you know, how is it really a second chance if we've already decided that they're not going to make it? So it's earning a second chance, but it's also being deserving of you know, America living up to her promises and having a first chance. So I will turn it now to all of you, since you've listened to us for quite a bit of time now, for audience questions, before I close with a lightning round. So get ready, panelists. And please speak into the mic, as I've been instructed to tell you, because it's being recorded. So, Stefan, I'm going to pass it to you.
Thank you, Jasmine. One number that I always hear referenced to but never stated is, what are the number of negligent hiring suits in this country, and what is the dollar amount paid out? And I'm with the Council of State Governments, and we've supported, you know, several dozen efforts of businesses around the country getting together, talking about hiring individuals with criminal records, and they always refer to this concern. And I'm just surprised that we're never able to give them a number of suits and dollar amount. And is that because there is a concern that a lot of this stuff is hush-hush, non-disclosure agreements and private settlements? But I'm sort of curious as why can't we sort of furnish those numbers to at least dispel the most critical myth that concerns employers?
We've all turned to Sharon here.
I personally think, after having looked for those numbers for years, it's because there's so few of them. They don't exist. There's a handful of them every year, and you know, occasionally they're big time stories, usually not. I've been listening to this employer explanation for years already. I used to be on panels with employers who would say exactly that. And my response was, You know, you can talk about a handful of negligent hire cases. I can talk about thousands and thousands of cases where you have not hired a person in violation of the law. And when you become as scared of me as you are of them, then we'll know we've finally made some progress. And I'm happy to say we're getting there. That employers are now talking about the fact that they understand EEOC has put out policy and they understand that there are ban-the-box laws. But, you know, there's no sizzle in the pan that shows that the negligent hiring thing is nearly as big of a deal as employers often claim that it is.
Yeah, just to piggyback on that, the way I've been having these conversations with employers is to say, okay, so you've been employing in this space and these are your colleagues. How many of you have ever been hired, you know, and no one raises their hand? However, how many of you have been sued for failing to hire somebody as a direct result of having a criminal record? And, you know, they're hesitant because they have been sued, maybe it hasn't been successful. However, there are big cases that I referenced. The Coca-Cola case is one. And people know that, so Sharon's right in saying that, yeah, the bigger threat is actually you being sued by people who have criminal records that you haven't hired before.
Bill, you know, I got it. I mean, persuade me. I've used some of that language. I still don't understand why we don't, if it's so little,
Yeah.
isn't there some accredited group that can just sort of document it and just sort of state it? And that sort of helps, like this, it's good for us to know 70 million individuals have criminal records, right? We don't say a lot of people have criminal records. It's good to have that number. And it'd be part of a good research agenda.
Yeah.
Let's get that number. No, let's not make up any numbers, no.
Don't tell anyone we made it
That's
up.
not
Bill.
data-driven, Bill.
I'll say this as the person from a think tank sitting here. I'm very interested in putting our numbers people on this and actually chasing it down to see if it is possible. When we came up with the estimate of the number of kids with parents with records, it was because it was unknown. And people had said, well, we know it's probably a lot, right? And we had no idea. And the estimate we came up with was incredibly conservative, but it's been really powerful because, as you said, it puts a number to something that was previously a dark figure. I'm fascinated by this. I have been for a while. I know all of us have. So interested in taking this back and doing some work. But I will say, even though there are almost no cases of voter impersonation fraud, we're still having that conversation. So don't get your hopes up too high.
I have a question and an answer. So hi, I'm Sonia from Root and Rebound. So I did a lot of hunting for negligent hiring statistics last year when I was writing a fair chance hiring toolkit for California. The closest I could get to numbers were from the National Work Rights Institute. I believe these studies were done in collaboration, I may be wrong, with the National Lawyers Committee when Ray McLean was still in their employment project. But here's what I have for you. But this is old data. Over the last decade, this was a 2003 study. The average cost to an employer related to defending negligence claims for hiring a person with a criminal record was an average of $5 per worker that hired with a record. So it would add a $5 liability to hire someone with a record on average. A study of negligent hiring claims filed in 2003 showed that only 10% of those negligent hiring claims involved any person with a criminal history, and only half of those claims had favorable decisions. And of the ones that had favorable decisions, I don't have them in front of me, but for folks who like case law, I mean, again, it's the ones that screamed at you, where like, it was kind of like Catholic Church style cover-ups, right? Where it was like someone had molested a child and then in the same year got moved to another position with children. So it was pretty egregious. Everybody agrees, you know, negligence hiring happened there, if not more than just negligence. And then the last statistic I have is only about 1% of employers have ever been sued for negligent hiring of a person with a criminal record. Again, this is old data. And the percent is significantly lower, again, for cases where they were found liable. So that was the data I have from 2003. We're now in 2017. But I also, yeah. But I have a question too. So doing this work, mostly in California, though we're starting to do more work. We're a legal organization, some of you know us, working with people who have criminal records and people in reentry. Many of the folks who contact us are still inside and preparing for their release and sort of trying to navigate the obstacles and the things they hear about inside the walls that they know are going to come up. And one of the intractable issues I think we've come up against, and I want to hear your thoughts about it, two of them I want to mention. One is around the discretion in family courts. So for so many people, for a lot of, so many folks inside are parents reconnecting with their children is one of their top priorities among housing and jobs and other things that were mentioned. And the amount, for anyone who's been in a family court, the amount of bias and prejudice against parents of color generally, low-income parents generally, but now you're coming out of prison, you must have been a really bad parent. The amount of bias stacked up against biological parents reconnecting with their kids and the lack of legal representation for them. I've begged legal aid to take on these cases, and they're like, we just don't do it. We do domestic violence, so we can't. I'm like, how is that different? How is doing domestic violence work different from this? So that's really concerning to me, one. And second is similarly the discretion in parole and probation. So many of our folks recidivate, not because of new offenses or criminality or any of these like CBT ideas that are introduced at this conference. It's simply because they violated a technical rule. And if you give any person 1,000 rules to follow and put a camera on them or an ankle bracelet on them, we're all gonna. So those are two places where I've seen that immense amounts of discretion within the legal system is stacked up against folks, and Clean Slate isn't solving those. So I'm curious if you have thoughts about the way forward, or how do we take this on as advocates and open up that conversation?
Sharon should start because her organization actually has a practice that does a lot of what you just described.
Yeah, we do have a unit of lawyers that handle child welfare cases. And I'm happy to say that my understanding from those lawyers is that there's actually starting to be bipartisan interest in this issue, because a lot of conservatives think that the government should not be all over people's relationships with their kids. And it would be extraordinarily helpful if Congress took another look at the Adoption and Safe Families Act, easy for me to say, which is where a lot of the bad state law came from because they were looking to comply with the federal law. That doesn't change attitudes in family court, but it's certainly a start when you have, both representation and better law. The one thing that your question leads me to think about is the extent to which we all have an educational duty for so many pieces of the system. Just a quick story. We had a meeting with our DA's office in Philadelphia to talk about our expungement practices and how they could help us make the cases go more quickly. And we cited them the research on desistance that Rebecca talked about. 4 years out, you're not likely to recidivate. They didn't know. And I'm not talking about like first-year prosecutors. I'm talking about the people who run the office. Now, if DAs don't know about desistance research and employers don't know about desistance research, it makes you start thinking, I don't know, maybe we need to teach it in schools or something. But there's so much in this system that is governed by fear and prejudice about what having a record means, that is one of the major, I think, major issues that confronts us is how do we bust all of these misconceptions about what it means to have a record.
I want to say, you said Clean Slate doesn't address these issues, and now I actually want to push back on that just a little bit, not just because I'm up here doing an infomercial for a policy that I care a lot about, but because there are actually two ways that I think that it does start to get at these pervasive and really culture-based and myth-based problems. One of them is the very stark reality of housing. So one of the major barriers that people have, and you know this, to reuniting with their families is housing, and particularly public housing, which for many families is really that's the way that safe and stable housing is going to happen. And I'm thinking about Philadelphia and what an important role public housing plays, while not perfect. The difference between homelessness or shacking up on someone's couch and actually having your family somewhere that's safe at night. And because of the one strike and you're out rules of yesteryear that really still remain on the books until that statute is changed and until HUD policy is changed, you can be a parent who cannot reunite with your family physically, because if you come back in and you're not going to get back on the lease, right? Because the public housing authority is going to be too scared of you, and if you actually stay there and you're not on the lease, you're jeopardizing your family's either voucher or their unit, because if they find out someone not on the lease who, oh my God, has a record of staying there, then boom, there goes the thing that they waited for years on the waiting lists to have, and there goes the families' housing security. So that actually is something that with Clean Slate will be markedly less of a barrier. The other thing that I want to say about that, though, is just that there I believe is such an important handshake between policy change and culture change. And there's been so much talk today that is so important and led this morning by Daryl Atkinson, a good friend and someone everyone here needs to know, who spoke powerfully this morning about how language matters and about how that infuses what people think about other people, which then impacts the policies that we make. But I actually believe it goes both ways, and that as policies change for the better, and people like Bill can be out there actually sitting on this panel doing this work. Now you guys all know him, right? And that is a dramatically different situation than if it's just me and Sharon sitting here talking about people, which is not my theory of change, or at least my preferred theory of change. And so I truly believe that with policy change and with the physical and political removal of barriers comes the potential for culture change if we're intentional about it.
Yeah, I'm going to piggyback on that answer. So I think the way that I would approach that is I would approach it realizing that that's a hearts and mind thing, right? When you talk about a parent not being able to be with a child and then elevating the stories of that, promoting those stories and sharing those stories, it's going to infuriate people. Legislators, policymakers, advocates, and the people who are impacted by that issue, right? The thing that we don't want to do is not have families together. That's an American value. It's a core American value. So I would tackle that by looking to amplify it by intentionally wanting to change people's hearts and minds. So I would put that truth out there and let people wrestle with it and deal with it, and then suggest the policy change that could potentially alter that outcome.
I'm actually going to pick up quickly, too, on this question of technical violations, and I'm giving you all a preview of some polling data. We just did polling in Iowa at the Coalition for Public Safety, asking about a couple of issues, but one of them was, should people be put back in prison for technical violations of probation or parole? And at the beginning of the survey, 80% of people who responded, regardless of political affiliation, said yes, you should. And then they were read three messages. One was about sort of the arbitrariness of some of the technical violations. One was about the massive driver they are of the overall population in some places. And the other was about giving people more of a second chance and allowing them to reenter. And after being read just those three message points, support dropped to 51% from 80, which is what I was just looking for on my phone to make sure I got the number right. So I think to go back to that imperative of education, I think a lot of people don't understand, again, how sort of arbitrary and, very technical and small some of the things that constitute being sent back into the system are. And it creates space for then telling human stories and creating the sense of, there, but for the grace of God, go I.
Yeah, people don't know what the cost of incarceration is, period.
Right.
We incarcerate people that live in urban areas, and then we put them in rural communities where there's a wall and nobody knows. But people don't know the physical cost. They don't know the cost on the family. They don't know the cost to themselves as taxpayers. They don't know the cost to the economy in which they're a part of. People just don't know the cost. So we need to do a significant amount more education, and we need to do it in a very basic, fundamental way. At a level in which people can get. We use terminology like bail and pretrial, but when we're talking to the general public, those definitions need to be defined more broadly. So a significant amount of education delivered at a level in which people can digest it, feel something, and then be motivated to act.
Absolutely. I think we have time for one more question. Your hand shot up in the back, and then you seated it. So are you passing to the front? Okay, it's all you.
Thank you. My name is Emily Hoffman. I am an attorney at the Community Service Society here in New York, and we are actually in the early stages of trying to get a campaign for expungement or more expansive sealing in New York off the ground. So if there are local folks who want to connect on that would be great. I had two questions. Feel free to answer to the extent that we have time for. So the first question was, Rebecca, you mentioned when you were talking about the legislation in New York, in PA, that law enforcement was amenable to the idea partly because it was sealing versus expungement. And I guess I'm just wondering, because that's a tension that it feels like we're really sort of trying to tackle, and maybe you get more people on board by talking about sealing versus expungement, but is there something that you lose by not going for expungement in full and like permanently destroying these records? And then my other question is just sort of, to me, this is just, and to everyone, I'm sure this is so intrinsically a racial justice issue, and I feel like sometimes when we talk about it, sometimes like that messaging is really strong, and sometimes when we talk about it, it sort of gets divorced from the racial justice issues, and we start talking about, 1 in 3 Americans has this, and this affects everyone, and we kind of lose the sort of like core, like dirty secret, but not really secret, that's kind of behind the system of mass incarceration, and sort of how do we navigate that tension between like talking about this as a problem that affects a lot of people and therefore needs to get fixed, and how do we like make sure that we sort of stick to like this is so intertwined with racism. So
I'll start with the first piece, but I also want to have Sharon chime in here and probably chime more heavily than I'm about to chime. So I think one thing that's really essential to keep at the forefront of your mind as we're thinking about decisions we've made in Clean Slate versus in, say, a broader expungement campaign, that at the heart of Clean Slate is that it's automatic. And that's a huge part of why we were very willing to go down the road of sealing as opposed to expungement, was that if we're talking about records being sealed with no opportunity for a judge to review the case and with no opportunity for the DAs to consider whether they want to oppose that record clearing, sealing as opposed to expungement made a lot of sense, and was something that law enforcement had a very strong case to make for why they wanted to keep those records. If you're talking about a bill that is expungement and it's not automatic, and you're considering expungement versus sealing, I think it's to some extent, I don't want to say entirely a whole other kettle of fish, but it's a lot different for that reason, and there's a lot to be said for destroying the record so that it doesn't exist anymore, and I would be the first to say how valuable that is, but Sharon should weigh in on this perhaps more than I have.
No, I totally agree with what Rebecca said. The fact that there's not going to be a judge paying attention makes a lot of stakeholders really uncomfortable. And I think that's made us more willing to negotiate with the many, many people who had something to say about our bill. I think I made a list of 10 stakeholders, but we changed the bill after they voiced objections. And in part it's legislative process, in part it's that when you're trying to do something immense, you have to recognize that you're probably going to have to make some compromise to get that immense thing done. So that's what we've done. But I would add that I have never had a client say to me, boy, I'm really unhappy with the sealing because I think law enforcement is going to arrest me again. That is not where their heads are at. Their heads are at, I need a job, I need a place to live. Some of our clients are not thrilled with sealing as it has played out in Pennsylvania, not because of law enforcement, but because other entities might have access to it. One way that sealing is not perfect, for some reason the FBI refuses to honor Pennsylvania sealing. So for clients who need FBI background checks in areas like child abuse, child care or elder care, financial work, casino work, it may not work for them just because of the technical reasons that the FBI say we're going to report this case anyway. Or it may come up in a Brady check. It's those non-criminal justice pieces of sealing that may have been written in as exceptions that upset people.
Yeah, I think I'll talk about the racial justice piece because our campaign, the goal is to reduce jails and prison populations across the nation while combating racial justice in the criminal justice system, while combating racial disparities in the criminal justice system. It's a difference between selling something and then the outcome that you want produced, right? So I'm a salesperson. I know that people are inclined to do business with people that look like them, or inclined to buy into things that impact them directly. As a black man with a criminal record who is a professional advocate, I certainly understand the linkage between the criminal justice system and racism. However, it doesn't always bode well for the outcome that I'm trying to produce if I'm saying this impacts black and brown people disproportionately and that's unfair and that's not who we are. And because this is being recorded, I won't say what I'm thinking. But what I'll say is that it should be very clear to everyone that our nation is not what we say we are, but we are what we say. We are what we've done and what we continue to do. There are not a lot of people in power who care that it disproportionately impacts black and brown people, because their response will be, well, black and brown people commit crimes at a higher rate. So when you're selling something, it's not always to your benefit to actually say that, but what we're doing in our efforts is making sure that all of our goals, whether it be litigation, legislation, organizing, are all done with keeping in mind the disproportionate impact on black and brown people. So we won't pursue certain things as a result of it not actually producing an outcome that changes the racial disparity. And a great instance of that is what transpired in New Jersey as they reformed their pretrial part. However, racial disparities have now become the worst in the country as a direct result of people not considering how it's going to impact black and brown communities, whether or not this change is going to increase racial disparities or decrease it. So that's the way in which we're always thinking about the work and our goals and our objectives. And then when we're selling, you tell the audience that you're in front of what they want to hear so that they'll buy it. And that's it.
I mean, the other thing, I'm going to jump in really quickly and just offer, like, I have a criminal record, right? It's an expunged juvenile record, and I think that there is power, particularly I come from rural white America, in people who know me understanding someone who has a record also looks like that. And I believe that that is ultimately how you get to undoing some of the racial prejudice, is saying people who look like me experience this, maybe I have to shift my conceptions of the other. Because I think we have done ourselves a bit of a disservice to tell, this vast swath of America who is primarily poor, who sometimes come from very white areas, that this issue does not also belong to you, particularly with local jail incarceration ticking up at a crazy rate in some of these small, very white counties. So I would say, we need everyone all in, and racial disparities exist, but we need a panoply of messengers to talk about them.
Yeah, like we need to acknowledge that white women are actually the fastest growing portion of the prison population. Like white women are, who would have thunk it?
Right.
Because we're always talking about how it impacts black and brown people or other particular communities, but yeah, it's the fastest growing population.
I think we are at the time when we have to close, so if you want to talk further and know what Bill would have said when he wasn't being recorded, come find him after the panel. But quickly, I'm going to do a lightning round and ask all of you to say one thing that when people leave this room, you'd like them to think about differently.
Starting with me?
Sure, if you're ready.
We took down the slide, but that's all right. 100 million people. Let's keep in mind all 100 million people. We've heard about the people that have got the violent convictions. I certainly agree. We want remedies for them, but we also want remedies for people with the non-convictions and the crazy crap that's keeping them from getting jobs too. So we're in it for a solution to everyone.
Is crazy crap the legal term?
Exactly.
So I'm going to take this big picture. So I told a number of people, friends of mine, where I was coming, why I was coming to New York, and they said, "Oh, you're doing a thing on criminal justice. Well, didn't that kind of end? Didn't that like have its moment, and now isn't that over? I thought you were working on other stuff now, right? Like multiple of my friends, and you know what? They should be forgiven for believing what they've read in the newspapers or whatever other source of media there is today that sounds less like 1990s. They should be forgiven for believing Twitter or Facebook because that's the story that's been told, is that criminal justice reform is dead post-election and that we're going to have to wait for another election for it to be revived. Well, guess what? If there's one thing you leave thinking differently about, it's that, I hope, from this conference, because not only does there remain tremendous bipartisan momentum outside of government, but also in a lot of parts of government for solving solving these problems, but the momentum is not just alive and well in the states, it is chomping at the bit. And that is where we can make so much difference right now, that if we have to say there are some question marks in Washington right now, let's turn our attention to where we can get things done. You better believe there is a tremendous amount we can get done in the states, which frankly is where most of criminal justice policy is.
Yeah, I'll just leave you with second chances aren't given. Second chances are earned. And people who have served time in our nation's jails and prisons to completion have earned a second chance.
Beautiful. Go forth, do good work. I hope to see you all tomorrow, and a huge thank you to all three of you for having a vibrant and interesting and intelligent conversation with me today.